This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast. How are you all? Hopefully you've had a nice week and are looking forward to a wonderful weekend. I am Stuart Address, and this is Ask a Lawyer. Some of you are familiar with it. If you're tuning in for the first time, call me. Ask me a question. Who knows? You may get an answer. You have a problem? You might need to sue somebody? Somebody's threatening you to sue you? Give me a call.
Well, we hope not, right?
Well, it happens.
Yeah.
That's why I get all these calls in my office all the time. And if you don't want to call and talk live on a radio station, you can give Cheryl at my office a call. It's 772-781-8003. And if you want to call us here, which is wonderful, it is 772-340-1590. So, I understand we have a $1 billion jackpot this weekend.
I bet by the time they do the drawing, we'll be there. I mean, it's so close to $1 billion.
I'm pretty certain. Yeah. It's $970 million last time they gave a formal number. I'm pretty sure it'll be over $1 billion. Gee, what would we do with $1 billion? Well, I can tell you what we'll do with $1 billion. If you
I'd have to get a financial advisor.
If you want it up front, it's probably going to be about $500 million.
Okay.
And then from that $500 million, you're probably going to get about $300,000. So the billion all of a sudden becomes $300,000.
How does that happen, though? How do you go from, I see cut it in half, you paid taxes, right?
Well, no, cut it in half because you're not being paid overnight. You're not taking an annuity.
Oh, it's the lump sum thing.
The lump sum.
All right.
So it's probably roughly half, about $500 million. And then you pay the taxes, roughly 40% or so. So you're down to $300,000. Doesn't seem like a heck of a lot of money now, does it?
No.
I'll take it. Anyway, if any of you are lucky to ever win the lottery, or even a significant amount in the lottery, or if you get a nice inheritance, let me give you one suggestion. A suggestion that if you watch some of these lottery shows, you realize a good number of people that have won the lottery fail to heed.
Mm-hmm.
It's not immediately run to the bank. It's run to a lawyer, run to a certified financial planner, before you even deposit the money. Because you can make a deposit and do the wrong thing. It could have adverse tax consequences. Mm-hmm. Get the check, put it in a safe deposit box, consult with a lawyer, consult with financial planners, know what you want to do with it.
Hide from your family.
Hide from your family. You're going to get calls from every charity in the world and a lot of fake ones.
Yeah. Cousins you didn't even know you had.
Absolutely. But the number one advice really for anybody after you get through the euphoria of I've won, is you need a lawyer and you need a financial planner.
Mm-hmm.
And I'm not saying it's necessarily me because I do general civil litigation, but it is an important piece of advice, especially with $1 billion. $1 billion sounds like that type of thing. I don't know if any of you remember my age. I used to watch Get Smart, and with Don Adams.
One of my favorite shows. Yeah.
Missed it by that much.
Yeah.
It always started out with a big number. And missed it by that much. And that's what it reminds me of.
I always forget to play.
I tend not to play because I figure I'm not going to win. But then they say if you're not in it, you can't win it.
Yeah. And usually it's like one, sometimes there are multiple winners, but usually it's just one guy
one guy that is playing it with 20 of his friends.
Yeah, right.
Then they really win very little. But okay. So what about legal topics? Figured we'd do a little bit of a smorgasbord today.
Okay.
A little bit of a buffet. You go, you look, you take, you sample. Figured we would talk about the types of calls we get into my office and how they start out. because they seem to run into a good number of continuous formats, depending upon the legal area that we're talking about. So, if we're talking about discrimination, sexual harassment, race discrimination, age, religion, national origin, all that kind of stuff, which is Title VII of the Civil Rights Act under federal law and the Florida Civil Rights Act under state law, we get calls like, my boss treats me, fill in the blank. So we'll get calls, my boss treats me like a child. It's not against the law. There's no law that says your boss has to be nice, and that's the reality. My boss is always cursing at me. There's no law that protects you from being cursed at or demeaned by your boss. The law protects you based upon what are called certain protected classifications. If your boss or a coworker or a supervisor are either speaking to you or giving you lesser duties or making you do more work because of your gender, because of your race, because of your religion, because of your national origin, because of your age, it looks like maybe not so much, depends upon the new Supreme Court, because of your sexual orientation. The Equal Employment Opportunity Commission says yes, that's part of gender. A lot of the conservative courts so far have said no. So whether or not sexual orientation is truly protected is up in the air. And we'll see how that comes down, and I'm not confident. But the whole point of Title VII is to protect you from discrimination based upon protected classifications. And so when your boss generally treats you in a miserable, demeaning way.
Like garbage.
Right. The hard truth of it is you have two choices. Stay or leave. It's not sue, because you're not going to get anywhere. We get calls.
Do you have to see if that person is treating other people the same way? I mean, maybe that person just treats everybody like garbage.
That's a very good point for somebody who makes very few of them because you're such a conservative. No, that is a very good point. If your boss is an equal opportunity jerk, then it's not.
That's just who they are.
It's not based upon a protected classification.
Okay.
It's just an equal opportunity
and part
jerk.
of that could be opinion. Maybe that person doesn't know they're being a jerk.
Well, the interesting thing is if they don't know, and honestly, it does happen. It does happen that, you'll treat somebody in a way that is offensive to them, and you don't realize you're doing anything.
Because people could be more sensitive than other people.
Those kinds of supervisors, bosses, if you point it out appropriately, that's the key word. You don't get in their face, because then you're going to get fired for insubordination. You let them know appropriately that, I didn't appreciate, I don't like, it sounds to me. Those types of bosses, supervisors, tend to apologize and change. Honestly, I mean, they do. We have cases where, somebody wants to sue, but it's already been fixed. And one of the points of Title VII and the Florida Civil Rights Act is you have to complain because you have to give the employer an opportunity to conduct a reasonable investigation and to take appropriate remedial action. Otherwise, they have a defense no matter how you've been treated. So let's say it's your direct boss that's mistreating you. If they're the right kind of person and you tell them and they make a change, then no, you don't have a claim. It's not what the law is designed to protect. Matter of fact, the law did what it was supposed to do. You said something, they modified their behavior. But if you complain and nothing's done, and it truly is an aspect of discrimination or sexual harassment, then you have a cause of action. Now, if they punish you, now you may also have a cause of action for retaliation. And the interesting thing about all this is, let's say you complain, for example, about sexual harassment. And let's say they do a real honest-to-goodness, serious investigation. and they determine you were not sexually harassed. And let's say they determine that, and they're right. You weren't. You were just ultra sensitive to an innocuous comment that was made to you. But you're fired. You will lose your Title VII claim. You will win your retaliation claim. You can prevail on a retaliation claim even if what you complained about is not a violation of the law. You are protected merely by going to your employer and complaining. And that's something that I think most people don't really understand. Because they say, well, if it's not this, and, no, if it's not this and you're punished for speaking up, you have other rights. So we get those types of calls. And sometimes we get calls where we don't think it's discrimination. We suggest that you follow the policy. Call us back if anything bad happens, and sometimes we get a call back.
Yeah. Well, because I guess that's the first deterrent. You're afraid to say something because you're afraid of that retaliation.
Right, and let's talk about that. Let's talk about that for a moment, because isn't that why Professor Blasey Ford waited 30 plus... I know you don't believe so. Okay, I know you don't believe so. But isn't that why she waited 30 plus odd years before she went public, even though she had told her husband, she had told her therapist many, many, many moons ago? I personally could tell you, we have gotten numerous calls to our office on discrimination issues generally, but on sexual harassment almost all the time, where the complaints have not yet been made. And we have to explain that the law requires...
Well, that's only fair that you give your employer an opportunity to remedy the problem.
But we have people, especially the worst of discrimination, the worst of sexual harassment, the last thing they want to do is complain and be retaliated against. And that's what they fear. They fear the loss of their job. They fear being ostracized. They fear being humiliated. And very often, those fears are legitimate fears, are reasonable fears. But in a pair of Supreme Court cases, one of which came out of Florida, Boca Raton, which is known as Farragher, the Supreme Court determined, and I think correctly, you must complain to your employer. Otherwise, the employer has an absolute defense, even if you were discriminated against or sexually harassed. If you do not give the employer an opportunity to conduct a reasonable investigation and take appropriate remedial action, then you cannot hold the employer responsible. And even as an employee's attorney, I agree with that. Now, there are a lot of ways to make the employer to complain. Very often, you may have an employee handbook that tells you what to do. First, go to your supervisor, then that doesn't work, go there.
Yeah, or if you have an HR
go
department.
to HR,
yeah.
Or if it's a big company, call national HR. Sometimes it's even anonymous. So they give you a code that proves that you called them.
Okay.
Your employer is supposed to keep your complaint confidential. Okay, here's the truth of it, folks. If you expect your employer to investigate, and they're going to go to ask some people whether they've heard or seen instances of sexual harassment against Janine, it's going to be pretty obvious that Janine complained. It's the reality of life. They don't have to say anything, but it's going to be a reality of life.
And that person who's doing the harassing is going to know who turned them in.
Yes. And I could
But that's
see,
almost proof that it's been done.
Well, it's not proof it's been done unless the person really did it. But I understand the fear of working for somebody who you've just complained about. Probably the best thing a larger employer can do, and I've seen it done, and I've asked for it to be done, is to put that employee on paid leave until the investigation is concluded. You can't put the employee on unpaid leave because that's retaliation.
Sure.
Okay? If you're going to send the employee home, it better be paid. If you're going to move the employee to another department or another office, it better be paid and it better be an equivalent position, at least pending the outcome of the investigation. There are things that can be done to protect anybody who complains about discrimination or sexual harassment. And if when they call our office, if they haven't complained, it's one of the things we try to explain to them, how to navigate the process simply, and then if it doesn't work out, call us back.
Mm-hmm.
Because at that point, there's nothing we can do. They don't have a case.
Right.
So the best we can do is to explain to them how to have a case. And famously, I did that against Seacoast Bank probably about a decade ago, where a woman went into the branch. She worked there, and she was on the phone with her daughter's psychiatrist because her daughter was threatening to jump off the Fort Pierce Bridge with a baby, and they wouldn't let her leave to go to the bridge because they couldn't open the bank unless they had a certain number of people in the bank, and that's by law. Well, grab somebody else in 5 minutes and let this person leave. But anyway, she then needed to take time off. Well, she had rights under the Family and Medical Leave Act. She had never heard of the Family and Medical Leave Act. Family and Medical Leave Act is a very interesting statute. It's probably the only statute I know of where the employer has the obligation to affirmatively tell you of your rights. If they hear of anything that makes them believe you may be entitled to leave, they have to tell you and give you an FMLA packet. Then you fill it out and see if you're really entitled. So anyway, I get this call while I'm on 95 from this woman, and, I tell her, well, look, just send an email right now or fax something and put FMLA, and let's see what happens. Because they didn't want to let her have time off. They wanted to give her 2 days off. Well, lo and behold, the word FMLA got her leave. So now the question was, after she was done with her leave, she's supposed to come back to the same job or a substantially equivalent job with same pay. Sometimes the employer cannot hold that exact job open.
Mm-hmm.
I understand that. But they have to make sure that while you're out, they're thinking about you, so that you're either coming back to the same job, they put a temp in that position, or if they're going to give you a different position, it is a substantially equivalent position.
Yet when they make cutbacks for financial reasons, they
different.
make two people do the job of one.
Well, that's true, but that's different. So in this situation, she finally got her leave because of FMLA, and she didn't need me. But she came back, and oh boy, was she punished. So then she called again. And we had a 2-week trial in federal court, which she won. That sometimes the first time a client calls us, they don't become a client. We'll give them some guidance, and hopefully, honestly, they end up, you give them the guidance, and hopefully they don't need us. But if they do, we're there when they call back. So then we get calls, it's a hostile work environment because, and they've heard that, the law prohibits hostile work environments. It doesn't. The law prohibits hostile work environments arising out of a protected classification. So just because your boss is a nasty SOB, it may be hostile in the real sense of the word, but it's not a hostile work environment under the law. It's a hostile work environment when you're being discriminated against or sexually harassed. That's what the law means by hostile work environment. So then we'll get a call, I've been retaliated against because. Well, sometimes they have a primary claim. Sometimes they don't have a primary claim. It's just a retaliation claim. They might have a retaliation claim because of discrimination complaints, sexual harassment complaints, complaining about overtime, complaining about wages, filing a workers' comp claim, going out on FMLA, filing for disability, you name it. If the employer takes inappropriate action against you as a result of you even attempting to exercise what you think are your rights, you have a retaliation claim.
What if you come in 1 week and you're told, well, now you're really part-time, you're not really full-time, but none of your duties are going to change and your hours are not going to change. You just no longer are,
Getting benefits?
You can't get benefits.
Well, okay.
And it was the result of, okay, Let me give you the whole story.
Because I was going to give you a quick a quick answer, and then I realized it's a more nuanced question.
There was more to it. New insurance availability for everyone working at the company. One person decided not to put their family on there, but the insurance company thought that they could come back and put this family member with pre-existing conditions on at any time, so they denied the policy to the entire company.
All right, I don't.
And
know
then that employee came back next week and now is part-time.
All right, I honestly don't know how to answer that because there could be an ERISA claim there, Employee Retirement Income Security Act, which is really where all the health care benefits fall.
I mean,
under
there
ERISA.
were no health care benefits. This would have been a brand new policy. This was something new to the whole company.
Okay.
And then that company said, no, we don't want you because of this one employee.
You mean the insurance company?
Yes, the insurance company. So then the employer said, well, this person who was eligible for benefits is no longer, you're part-time now instead.
There could be something there.
Mm-hmm.
I mean, that would require actually some honest research. There could be something there. You know, the general rule is you can't be treated differently than other employees. So and this is under ERISA, if benefits are going to be offered, they're offered to everybody. It's why an employer cannot decide, I'm going to take out a group insurance policy because I want to have my family covered, but not offer it to the employees. You can't do it. If you're going to have group insurance, it has to be offered to all employees.
Mm-hmm.
Now, you can have a policy created where you cover the premiums, you cover 10% of the premiums, 50%. You can have any policy you want created,
Mm-hmm.
but it has to apply to everybody, including you.
Okay.
Okay? So if you only want to cover 10% of the premium, then you're paying 90% of your own premium out of pocket.
Mm-hmm.
And that's just the way it is.
And they can do that math any way that fits
They have to prepare a
financially.
policy. I mean, insurance companies know how to do this. It has to satisfy the requirements of ERISA. And they know how to do that. And if they don't, then that's a violation of ERISA.
Mm-hmm. Because I've worked at companies, too, where some of the people got their policies paid 100% and other people paid into their policies.
Now, were they in different classifications?
Well,
different levels?
it was
different time with the job?
broadcasting, and it would have been the sales department versus the on-air department.
Okay. It is possible, I don't know for certain, that you may be able to have certain differentiations.
So benefits
based upon
package.
job classification.
Okay, a benefits package for one person can be different than a benefits package for another.
I would not say one person. I would say it's possible you might be able to do it based upon job classification.
Well, they get away with a lot of stuff out there, don't
Oh,
they?
yes, they do. But this is when lawyers start looking at things more closely than we can on the radio, and this
Yeah.
is when you start, taking a quick look at research and trying to fit it into the fact pattern.
This was a long time ago, too.
Okay. The reality is, I don't care even if you're a specialist in something, which, there are specialists out there. They're certified by the Florida Bar.
Mm-hmm.
Okay. Most lawyers don't know everything. Secret there. They don't know everything. The reality is, even though it's 33 years since I was in law school, my gosh, that scares me when I think of that. The reality is what all law schools tell you, first year of law school, then and today. We're here to train you to think like a lawyer. Half the law they're going to teach you won't be the law when you graduate, or much less 30 years later.
Sure. Mm-hmm.
Okay? Understanding certain basic legal cases that are going to remain forever. Marbury versus Madison, and they're going to be there forever. No court's going to change it. Okay, you need to know it. But abortion, capital punishment, it's going to change. So their concern is not so much that you know the law, it's that you understand how to think like a lawyer when you're analyzing the case books and everything they give you. And the goal is to graduate lawyers who know how to think like a lawyer and over time think like a lawyer even better. So what does that really mean? It's very simple, honestly. It's not think like a lawyer and be a jerk. I was going to say a different word. I'm never sure what I can say on the radio.
Jerk is good.
Okay. But what it is you need to know how to find the answers.
Okay.
You need to know how to research the issue. So you know a little bit about something, and somebody comes in with a little bit more complicated fact pattern. You can say, oh, I don't know, and go to a specialist. But generally what you need to do is figure out how to get that answer. I mean, look, I do overtime law. The primary exemptions are 3 or 4 or 5 exemptions that account for 90% of all overtime cases. But are there 3 or 4 or 5 exemptions? No. There's like 200 of them.
Mm.
If they gave me a test right now, I'd flunk it. I can't name 100 of them.
Sure.
I've never dealt with them.
Right. They haven't come up yet.
Now, I had a case 5 or 6 years ago under the motor carrier exemption. What the heck? Let me tell you, I learned the motor carrier exemption. I litigated the case, and we did very well.
Mm-hmm.
So how did I learn about the motor carrier exemption? I thought like a lawyer. I did what I was trained to do. I understood the general law. I went into the statute. I found the exemption. I researched cases that interpreted the exemption, got an understanding of what the courts were saying, how they were applying the law, and then I applied it to the facts that the client had presented to me, and I gave an opinion. That is thinking like a lawyer, and that's what you're trained to do. So, there are lawyers just like there is anybody else, doctors, whatever. Somebody asks you a question, you're embarrassed to say, I don't know.
But is every case a research project?
No.
Okay.
Because there are certain things
You
like
just
the
know.
back of your
Okay.
hand.
Mm-hmm.
Okay. If you're going to file a brief, you're going to do the research to get the newest cases and the newest sites.
Okay.
But you know it like the back of your hand. That's true. But for the most part, unless you're dealing with one area of the law, if you're a tax lawyer and you're only dealing with derivatives, well, maybe you know it like the back of your hand. But if you're a tax lawyer and you're dealing with all tax situations that could arise,
Mm-hmm.
I guarantee you, even that boring tax lawyer is going to have surprises thrown at him, which will make him all excited because now he has to do something interesting. Or, look, tax lawyers think it's fun, so I'm making fun of tax lawyers. I could say the same thing about patent attorneys. I think that is the most boring job I can imagine. Patent infringement is fun, but
Okay.
doing a patent and getting a patent file, oh gosh, I don't want to deal with that. But look, there are patent attorneys out there that truly enjoy what they're doing. Well, okay, that's why they're doing it.
Mm-hmm.
That's why you want to go to them for that type of a project. You don't want to go to me, who doesn't want to do it, because you're not going to get a good job done, no matter how hard I may try. So, that's that kind of thing. Or we'll get a call. I have a discrimination case, and I just got my right to sue letter from the EEOC. Honestly, I hate when that happens. Because what does that mean? It means the employee did the right thing and complained, and then also filed a charge of discrimination with the Equal Employment Opportunity Commission or the Florida Civil Rights Commission.
Now, who would have guided them to do that? The employer?
They could have, no. Oh, God, no.
Oh, okay.
Oh, you kidding me? That's like asking the devil to send you to heaven.
Well, how do you know you're supposed to do that?
A lot of people just know from
Okay.
common culture or the movies or whatever.
Yeah, or they heard it somewhere.
The problem is I can't stand it when people have filed their own charges of discrimination. I can't stand it when I haven't written it. Because if it's not in the charge, it can't be litigated.
Ooh.
Yeah. So now they say we have a right to sue letter, which means you now have 90 days to file a lawsuit or lose your rights forever. All right. So now I've got to look at the charge and see, am I comfortable that the charge closely says what they're complaining about? If so, okay. If not, they can't complain about it because it's not in the charge. Or what happens, and it happens, let me tell you, I don't know why. We get a call, I have a right to sue letter and it expires next week. Can you file a lawsuit? Now, look, these types of cases are generally handled on a contingency fee, not an hourly basis.
Mm-hmm.
If I got a call from a kind of a case that's handled on an hourly basis and suit has to be filed tomorrow, can I do it? In other words, can I work all night and get it done? You want to pay me? Sure. You want to call me, especially as a solo practitioner, and tell me you need to file suit in a few days because you've sat on it? No, go somewhere else. I'm sorry. We don't handle it. I won't handle it. Now, I mean, if it looks like it's $1 billion case, maybe I will. But generally, no, I won't. It's, there is actually a lot of work that goes into drafting a quality complaint. Now, could I slap together, it's really interesting, could I slap together a basic complaint and get it filed so that we meet the statute? Sure, I could. And what will happen, either I can then move to amend to do a nicer complaint, which I have the right to do at least once, or what typically happens these days, I have a client I just told this to today, almost always in response to a complaint there's a motion to dismiss on some ground or another. It used to be those were not typically granted because it's not a real dismissal even. It's usually a dismissal with leave to amend. You just file an amended complaint. Whatever the court decided, you didn't quite plead that the way I think you should, so now you have a roadmap, you go back and you plead it the way the judge wants you to plead it. Okay. That used to be the exception. It's now the rule. There is no case other than the simplest case, really, where there isn't a motion to dismiss and 80% of the time it's granted with leave to amend and you fix it. Then there's another motion to dismiss, the amended complaint. Sometimes that's granted too and you fix one or two other things. And then finally, everything's hunky-dory. I now sort of alert my clients up front to that because otherwise they think, I was dismissed? Mm-hmm. So I diffuse the bomb before it ever is lit. That this is the way our system works right now. Virtually nobody files an answer to a complaint anymore.
So they're just kicking the can down the road?
Yeah.
Okay.
But the good thing is, even while they're filing their motion to dismiss, I'm allowed to conduct discovery. Okay. The case, even when it's dismissed, it's not dismissed. It is dismissed technically, but it doesn't cease being on the books of the clerk of court because you have leave to amend. The case number still exists. Everything still exists. You're still allowed to send out interrogatories, document requests.
How much time does that give you?
It depends. Sometimes you get 10 days to file an amended complaint, 20 days. If it's really complicated, 30 days.
And if you don't, does that finally go away?
Well, then it's dismissed without prejudice. You have one more shot at the apple at any time within the statute of limitations. So getting back to the initial question, if somebody were to call me and say, I only have a week left on my right to sue from the EEOC.
Do you say, well, where you been?
We do. Well, honestly, we do. Because
what you waiting for?
Cheryl's going to say that. And Cheryl knows when she comes to me and starts telling me the basic facts, she knows what I'm going to ask her. I'm going to say, well, why haven't they done something? And if it's because they felt like just being lazy, I'm not interested. If they've gone to 4 attorneys, for whatever reason, and those attorneys didn't think it was a good case, but I look at it and I think it is, then at least there's an explanation as to why we're so late in the game. Maybe I'll take it.
Yeah, time got chewed up.
Yeah, maybe I'll slap together a bare bones skeleton complaint, get it filed, and then fix it. But generally speaking, if we're called late in the game and somebody wants us to do quality work,
that's hard, sure.
Unless it's an hourly case, to jump to that and not work on anything else. Larger firms can do it. We're not built to do that. Quite candid. And to go back to the other answer, if somebody asks me a question, I don't mind saying I don't know. Because my perspective is, I'm not supposed to know everything. I'm supposed to be able to think like a lawyer. And so, folks, if you want to call again, 340-1590. If I can answer your question, I will. If I can answer it partially, I will, and then I'll tell you the part I can't answer. If you've listened to the show before, you know that's really the way it works. And if I don't know what the heck you're talking about, because it has to do with something that I haven't seen in 33 years because it's not what I practice, I will gently tell you thank you for calling. I really have no idea whatsoever. Here's where you might be able to go to get the answer. But I'm not embarrassed by I don't know. There are attorneys, there are other people, plumbers, engineers, who make something up to sound good. I hate that.
Right. And that's why the cold water comes out of the hot side and the hot.
Just tell me you don't know. Tell me you don't know, and you'll figure it out, and I'll trust you a lot more. Okay. Looks like we do have a call. My plea has been heard.
Start with that
and
one.
we have Julie on line 1. Hello, Julie.
Hi, how are you doing?
I'm doing very good. How are you?
Very good, thank you. I listen, regular listener to the show.
Thank you.
A new one. I moved from Pennsylvania to Florida, so I'll sum up my question quick. My son was married in November. The following January, his wife gave birth to a baby. The baby was, the mother was addicted under the drugs. The baby was addicted, quote unquote, a crack baby. Mom went to rehab. Dad has custody of the kid. Filed for divorce. Mom went into rehab, came out, has nothing but problems. Take it to this year. They did grant the divorce. He does have full custody. She has visitation. She doesn't exercise her visitation. She's in and out of rehab, and she's supposed to pay child support, which she has not paid any at all. She's supposed to have drug testing. She's never done this. This is since March of this year.
Okay.
Nothing. He is thinking he'd like to go back and see if he could sever her rights as a parental right.
Okay.
And I wondered in Florida, how long you have to wait before you could proceed with that.
There's no period of time you have to wait. I will tell you that is really, really tough to terminate parental rights. The court is almost always going to want to leave that door open, because if she rehabilitates herself 10 years from now, then there's really no reason for her not to resume her role as a mother. If the child is in danger for whatever reason, yes, I can understand it happening. But generally, termination of parental rights in an adversary proceeding, not voluntarily, is very extraordinarily difficult to
and
obtain.
especially if they can't get in contact with her and serve her, they're not going to do it in absentia or whatever you call it.
Well, yes, actually, that's honestly, that's incorrect. If you're unable to serve somebody, whether it's in a family matter or any other matter, the rules provide how to engage in substitute service. Generally, you serve by publishing in the newspaper a certain number of times, as the statute will tell you, a certain size of an advertisement that follows the wording that the statute tells you, and then if there's no response, the court can proceed as if the person was served and take whatever action it deems prudent. So there are ways to serve people that don't want to be served. But still, to terminate parental rights would be difficult.
What
now,
if she were to agree? Could you?
Well, she's not going to agree.
Right.
I mean, they can't even get a hold of her. We don't even know where she is. But the issue, I think, is I felt that it probably is very difficult to sever her rights because and as you had said, so is this an exercise in futility and expensive for my son to spend thousands and thousands of dollars with an attorney who says he can go there and like you said, serve her, and if whatever they decide, she still has a chance to come back at whatever time
yes.
and say, well, she didn't go because of whatever. So is this just an exercise in futility?
Let me ask you a question. Does your son have an attorney that's telling him he can do this?
Yes.
All right. I do a little bit of family law, but I'm relatively new to it. I'm honest about that. It's not an area I've practiced for 30 years, so I won't even handle anything that's other than simple right now because it's outside of my experience. But I can tell you, I do know that it is very hard to terminate parental rights. If there is an attorney saying that he thinks he can do it and pay me $5,000, $10,000, whatever, the very least I would do is to go get a second opinion, go get a consultation from another family law attorney who is clearly experienced and knows what they're talking about. You can find them. You can call the local county bar association. They'll give you names.
Okay.
You can look them up under the floridabar.org website, or what I happen to believe is a phenomenal site is a site called AVVO, AVVO.com. It's a site, it's a private site, but it rates attorneys all across the country. And more important than the ratings are a lot of attorneys have references, people who have left reviews, just like a plumber.
Oh, okay.
Somebody has one review, okay. I know, for example, I have like 50 reviews. And so what I tell people is, don't listen to what 1 or 2 or 3 reviews say, because anybody could get a review written for them.
Right.
But if there are lots of reviews, 10, a dozen, whatever, and they seem to have similar themes, I think you can then start to rely upon this represents that kind of a person. This represents that kind of an attorney. They always get back to me, whatever. So I would look for an experienced family law attorney that, has a 10 or a 9 rating from AVO. It has at least, 10 reviews. And that's who I would probably get a second opinion from. If they tell you that they think they can do it, well, the best question is, well, why? I heard it was almost impossible. And if the answer is rational, then maybe they can. But if the second attorney says they can't, then I wouldn't spend the money.
It just seems common sense that although it seems in our day-to-day life this is a long period of time, in the court it can't be a long period of time, 2 years, can't be that long to take away someone's rights, the parents' rights. Because even if they're sitting in jail, you're not taking their rights away.
Right, and that's typically the way it works. It's visitation. Even if they haven't paid child support, they're not going to lose parental rights over child support. They can go to jail for not paying child support.
What if they feel as though they're a danger? Or
that's something else.
Then time shouldn't matter.
Then if you can't,
that doesn't even matter because that's protected under visitation.
You're right.
If they have supervised visitation and no custody, so that's already addressed. But
right.
I just think he's just throwing away $5,000 to start, just for the false sense of security that he's going to sever her rights.
My strong advice is to get a second opinion. It really is.
All right. I appreciate it.
You're very welcome. Thank you for calling and thank you for listening.
Have a good day.
Hopefully, I believe we may still have Rick on line too. Are you there, Rick?
Hold on one sec. This button.
Wrong button?
No, it won't press.
Button won't press. Technical difficulties. Please stand
There we
by. Okay. Rick, are you there on line too?
Yes, sir, I'm here.
Hi, how are you? How can I help you?
Well, my wife and I contracted in Port St. Lucie to get hurricane shutters put up.
Very good idea.
Yeah, so we thought. We're older. I suffered a massive heart attack. I got a bunch of stuff in me to keep me alive, and my wife just had a hip replacement. So we can't put them up, and it's a 2-story house. So we contracted with Shield of Protection, and we gave them $6,800. And we just found out that day before yesterday, that not only will we not be getting our shutters, we won't be getting our money back.
Why?
Because they said they got the IRS leaning on them and froze their accounts or levied them or whatever. And I don't know what to do.
All right. Well, you do need a lawyer. I don't know what the true facts are. I have had a lot of people give lots of excuses. IRS is not a bad excuse. Maybe it's true, but maybe it's just a bunch of baloney.
Well, a woman in a building contractor's office went there, investigated, and said that part's true. And they sent me an email in July saying if I gave them the balance in 2 weeks, we'd have our shutters.
Oh, no.
They didn't even pull a permit. Well, my wife got excited and ran and gave them the balance, so hence we're out to $6,800.
Okay. All right. Well, if they're still going to be in business, then I would think the first thing you want is a nasty lawyer letter to the company saying, perform under the contract or else you're in breach, and we'll take the remedies that are available for breach of contract. Sometimes, a lot of times, a nasty lawyer letter gets a company to decide, well, they're going to put you to the top of their list because you're the squeaky wheel.
Well, unfortunately, if you go on Google and look up Shield of Protection, there's a bunch of people very recently done the same thing as us.
Okay.
And with the same results and the same answer. So it really looks to be legit in that sense.
And that may be true, but the question is, do you know, are they still in business? Are they still operating?
I honestly can't answer that.
If somebody were to go there, are there still people in the office?
No, we went there. It doesn't even have their name on the glass.
Okay. Well, you may be in a very tight situation. It's possible.
Well, I just have a quick question,
Yeah.
if you don't mind.
Sure.
My wife actually, to make it worse, borrowed the money from the government because they had to fix our roof, and they gave us a very low interest loan. So we have to show them what we've been doing with the money. And
Like an SBA or something?
It's very low interest. I don't know what it is, though, but
Okay.
it's the government. And we got it, and that money is what they took.
Well, you may, again, now this is an area I don't know. You may be able to simply show the lending entity, even if it's a governmental entity, what has happened, and that, you have not failed to utilize that money to get the shutters, by doing anything wrong. And that may be enough. You're probably still obligated under the loan.
Oh, we expect to be.
Right.
Just
But nobody's going to accuse you of fraud because you took the money and didn't do the shutter. That's why they want to know. They want to make sure people aren't, getting money for fraud.
If you take the paperwork to them, would they help them out in any way?
Probably not.
Okay.
No, probably not. Probably the only way to be helped out, if help is even possible, is with a lawyer, either sending a demand letter, assuming they're still functioning, and if so, again, possibly then following it up with a lawsuit, county court, because it's more than $5,000, or to get it over really quickly. If they're functioning, you can always limit your claim to $5,000 and accept the other $1,600 as a loss, and go to small claims court, because then you'll be done in a couple months.
Based on the stuff we got back, it just does not look, I just don't know for sure, but it just does not look like they're able to keep their business going.
Well, you might be able to investigate that a little bit on your own.
But they said, hurry up and bring us the balance.
Well, and they did.
Yeah.
They were trying to get more money. The other option is to get a consultation with a lawyer, including me.
Okay.
You
don't have one.
You're going to pay another few $100, honestly.
We expect to do that.
But it may be worth it enough to, have, again, whether it's me or somebody else, use the resources we have to try to find out what's going on. And then if it looks like they're really still in business and they're just hiding, they went somewhere else and they're in business. Then, a person like me or me, might quote you a different amount to do a demand letter.
Well, they've been here, I can say honestly, about 17 years in business. I can't explain how they got into the position they got into. I've done business with them many years ago, where they put fencing around my pool and upstairs around my deck, so there was no problem.
Right.
With this, and now, like I said, if you go on Google, my goodness, it's 20.
Well, if you'd like, give my office a call. Cheryl will be happy to chat with you, and she's listening on the radio, so it would sound like you would need a paid consult. She doesn't need to screen you or anything. If you're interested, just give her a call.
Yes, I am.
It's 781-8003. And
781, I'm sorry, that was fast. 781.
I'm sorry, 781-8003.
Thank you so much.
You're very welcome. Take care. Good luck.
You too. Bye now.
Did we have a third one?
They dropped off.
I dropped off. They dropped off. Why? Come on. All right. If you're still listening, give us a call back, and we'll try to do something within the next 6 minutes or so. This is examples of, sometimes you can't help. Sometimes you might be able to help. Sometimes it takes using resources to try to figure out if you can help. It's not always easy. We had one guy who was getting a boat fixed, and the boat was never fixed, and all this money had been paid, and he was getting excuse after excuse after excuse after excuse. And the guy had been a friend of his, so he trusted him. He kept giving him money, never got the boat. Well, that guy is in jail right now because he was doing this to about 50 different people.
Wow.
Those people are not going to see their money. Even if there's a restitution order as part of a criminal matter, they're probably not going to see 100% on the dollar. It'll be a portion. depending upon what's there. Now, this guy happened to have a business that had all sorts of exotic cars. So the cars have value, and I'm sure they've probably been auctioned off by now. So there was money that would be in a kitty somewhere to help pay victims. But I tend to believe it's never enough for all the victims that have been victimized. But, you don't know those things. I mean, it was only a number of people complaining and writing demand letters and following up that finally got the police department to look into it and not say, oh, that's a civil matter. So many complaints of this, that turned into theft, turned into grand theft.
Well, he was friends with a lot of people.
Yeah. Well, sometimes the best con artists are very friendly.
Yeah.
And speaking, you can do this in any format, whether it's, again, a plumber, electrician, doctor, lawyer. Be careful about the smooth talker. Okay? The smooth talker isn't always the best person. Now, that doesn't mean the smooth talker may not know exactly what they're talking about. But it's really incumbent upon you folks to do your research. If you're coming into my office, when you leave, whether you've signed a representation agreement as a client or whether you're still thinking about it, we're going to give you a folder, and, it's going to have things in it, which include my reviews on ABBA. But, we ask a lot of people, it's a standard question, how did you hear of us when they call? Mm-hmm. Some of them, have very interesting answers. A client from, 12 years ago. Well, that's nice. Mm-hmm. Some of them, Google. Okay, but what does Google mean? Where? How did you find us? Some of them have looked at us on Avvo, and they've read the reviews. Okay? Some don't know who the heck we are. We're just an attorney they're calling.
They looked in the yellow pages, found your name.
Okay, yes. And that's fine. Happy to have them come in. Mm-hmm. But honestly, my personal opinion is you should be doing a little bit of research before you go in to see a lawyer, a doctor, anybody who may have a significant impact on your life. Do a little bit of research as to who are you going to see and see if there's any red flags that gets raised for you or whether what you find out sounds really good. And then after you meet the person, you're going to have an opinion just like everybody else as to whether you click. A person may be the most knowledgeable in the world, but if you don't click with them, you don't want to have a 2-year relationship with them. Trust me. On the other hand, somebody may be, let's say number 3 at best in the world, but you click with them completely. Well, that's really the person you want. Mm-hmm. I'm not saying go down to number 100, but you want somebody who you have trust in, you have faith in, you think you could deal with for 2 years. Life of a typical case. Anyway, we're just about out of time, as we always are. Very nice to chat with you.
Good calls today, too.
We got some good calls. I will be back next Friday with Ask a Lawyer. And in the meantime, feel free to call my office at 781-8003. I said it slowly. Thank you very much for listening, folks. Have a great weekend.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
CBS News on the Hour, sponsored by Zoom Video Conferencing.
I'm Steve Kaif, and